Good afternoon, everyone. Welcome to our first webinar of 2024, What You Should Know About H-1B Visas and Proposed Rule Changes. Thank you so much for attending our webinar. Before we begin, I want to be sure that we have our technical aspects done or working. So if you can hear me and you have access to the chat, please just type yes. That way I will know that the audio is working. All right, great. We've got some yeses there. So thank you very much. Again, welcome. I'm Ann Badmus with Badmus Associates, and our webinar today is intended to help educate you about the H-1B visa process, as well as potential changes that are coming, we believe are coming in the future. So before we go on, just some housekeeping things. So you can ask questions at any time. And with this platform, the best way to ask questions is to use the Q&A panel, which is, I believe, at the right of your screen and near the top right, where there's sort of a question mark bubble there. So there's a chat feature and a Q&A feature. We prefer that you use the Q&A feature to ask specific questions related to the webinar so that we can keep track of the questions a lot easier. For confidentiality reasons, we ask that you ask the questions in a general manner. Do not provide personal details because this is kind of a public platform and we want to make sure that your information is confidential. All right. So just a little bit about our firm based for those of you who are not familiar with us. Badmus Associates, our attorneys have been helping clients with legal immigration status since 1993. We have been honored to receive Best Lawyers in Dallas for Immigration in Dallas, as well as Best Lawyers for Immigration nationwide. And also our firm has been selected for the Best Law Firms list for the Dallas-Fort Worth area by the U.S. News and World Report. So now on to the webinar. Before going on, I want to make sure that it's understood that the content that we're providing in this presentation is really for informational purposes. It is not intended as legal advice for your specific situation because immigration is unique for each individual. It is better to reach out to an immigration attorney to actually learn more about your specific situation and advise you appropriately. So our agenda for today, we're going to cover a lot, so we will be going pretty quickly in the time that we have. But like I said, as we go along, feel free to ask any questions, put them in the chat panel, and we will address, in the Q&A panel, and we will address those questions towards the end of the webinar. All right, so our agenda for today, we're going to have a basic overview of H-1B visas. And as part of that presentation, we're also going to talk a little bit about some of the proposed changes to those H-1B basic requirements. We'll then talk about the H-1B cap and the registration process, which is coming soon in March. We'll then talk about H-1B cap exemption, which are for those people who are able to find employers or employment that would not be subject to the cap. And then we'll talk a little bit about the entrepreneur H-1B visa or the self-employed H-1B visa. And then finally discuss some of the other proposed changes. There are a lot of proposed changes, but we're not going to be able to address them all in this setting, but we will talk about some that we think are important for you to know at this point. And then we'll have question and answer. So to address H-1B basics, for any type of employment, it's very important to know that the job must be in a specialty occupation. That is key, and that is some of the changes that we're going to see with respect to the government's view of what a specialty occupation is. By law, specialty occupation means that the job itself must require a minimum of a bachelor's degree or higher in a specific field, and that the proposed H-1B employee must also have that required degree at the time that the H-1B petition is filed. So this applies, again, for any H-1B petition and any occupation. We must show that it is a specialty occupation. Another requirement is that there is an employee-employer relationship, because this is an employer-sponsored process. So it is actually the employer who is petitioning for the H-1B as opposed to the actual H-1B employee. So that requires that the employment is what we call, or typically is called a W-2 employment, direct employee, not a independent contractor position. And then, of course, the employee must only work with the sponsoring H-1B employer unless they also, if they want to work, or the employee wants to work with other employers, then the other employer, each other employer must also file an H-1B. And of course, that specific job for that particular other employer must also meet all of the requirements for H-1B as well. H-1B visas are typically granted up to 3 years at a time for a maximum of 6 years that the employee can have H-1B status. And this is the case regardless of changing of employee. So if an employee has received 3 years of H-1B work authorization with one employer and then changes jobs to another employer, then for another 3 years, then the maximum time that the employee can have would be the total of 6 years. So it is not dependent on the employer in terms of how long you can have an H-1B. It's dependent upon the employee and how long they have had the H-1B. So an employee can only have 6 years maximum. And then after that, they would have to leave the country for a year and then return and potentially be able to get another 6 years in H-1B status if they are able. Those employees who have a pending green card application, however, can get an extension of that 6-year limit. So that means that if you have applied for the green card within a certain time frame, and timing is very important, so we're not going to go into too much detail about that because of the time that we have, but if the employee has applied or is in the green card process, then it is possible to get an extension of the H-1B status from 1 year to up to 3 years, or 3-year periods as well. So it is possible to extend beyond the 6 years, but you have to have a green card process in place to do that. Another H-1B basic that employers and employees must know is that the employer must pay the actual or prevailing wage and the same benefits as they would pay any other employees in the same occupation. So what that means is that the prevailing wage is what the government says is the minimum wage that must be paid to an employee in whatever occupation there is. So if they're in an engineering position, let's say a civil engineer, they would need to, the employer must pay what they normally would pay to the higher of what they would normally pay to employees, other engineers in their firm with the same background or the same qualifications, or they must pay the prevailing wage, which is what the government says is the minimum wage to be paid for engineers in that particular location or particular county. So they must pay the higher of that. If the prevailing wage is lower than what the employer typically pays for civil engineers or its employees, and the employer must pay that higher wage. It cannot pay a lesser wage than they would for anybody else in their company with the same qualifications. For employees who are in licensed occupations such as physicians, some engineering, other accounting or CPAs, any occupation that requires a license, the H-1B employee must have that required license before the H-1B can be approved. They do not have to have the approval before applying for the H-1B petition, but before the H-1B petition will be approved, the government will request or require that proof of license is provided. And then H-1B visas can be full-time or they can be part-time. So that is a benefit for those who don't need or want full-time employment, or they may want to have several employers on a part-time basis if qualified. So let's talk a little more about the specialty occupation. As I mentioned in the beginning of the presentation, it is very important to establish that as an employer that your H-1B position that you're applying for is a specialty occupation. And the government has very specific requirements for proving that. So by law, anyone who is in an architect, engineer, lawyer, physician, surgeon, and teachers are considered specialty occupations. If you are not, so that is a fairly easy qualification to meet for those in those occupations. However, if you're not in one of those professions, then you have to do a little more to prove that your position is a specialty occupation. So the government says very specifically that a specialty occupation can be proven by 4 different criteria. So first of all, if you can show that a bachelor's degree or higher is the normal requirement in the industry for someone to enter into position. So for example, an IT position, if normally or the majority of people who are in a systems analyst position typically have a bachelor's degree in computer science, then that would be proof that that's a normal requirement for that type of position. Or you can also show that the degree requirement is common, even though it may not be the majority, but it may be a common requirement in the industry, so that most organizations who are hiring today, for example, in that type of position, do require a degree. Or they can show that the employer can show that the position is so complex or unique that only someone with a degree could actually fulfill that. Another way to prove specialty occupation is that the employer normally requires a degree for the position, even though maybe other employers do not. So a typical example of that would be nursing. The government typically does not agree that a registered nurse position in itself is a specialty occupation. However, if the employer typically always requires a BSN, Bachelor's of Science in Nursing, for all of its registered nurse positions, then that may be a way to show that it is a specialty occupation. And then finally, similar to the second criteria, the employer could show that the nature of the duties that are involved are really so specialized and complex that a degree is absolutely necessary. And that one is a little more difficult, but it will require expert opinion. It may require industry information, very specific job requirements that have to be defined and shown how those job requirements actually relate to any specific type of degree. So those are the ways that you can currently prove that there is a specialty occupation that qualifies, or that your occupation is a specialty occupation that qualifies for H-1B. Now, there is a proposed rule, not necessarily changing the actual regulation, but it is a change of interpretation that the government is proposing. Now, when we say propose, it means currently that it is not the rule, but it is anticipated that the rule will change based on the fact that the government did recently publish back in September a proposed rule. So these proposals that I'm referring to are proposals that the government has publicly announced, but they have not made official yet. But it's anticipated that sometime this year they will be made official. It may be a little varied from what we're discussing here, but there will be certain changes in the H-1B requirements. So regarding specialty occupation, the government is now proposing to very narrowly define specialty occupation, not so much different from the current rules, but as far as the degree requirement. So if you're saying that you need a degree for your position, you have to relate that to a very specific degree. It's not bachelor's degree required. It's bachelor's degree in computer science, bachelor's degree in education. Well, not education, but bachelor's degree in accounting, different things like that, that you would specifically have to relate. And if you have multiple degree types that you would accept as part of your position, you will need to really show how each degree type. So if you're saying bachelor's in engineering, or a bachelor's in computer science, or a bachelor's in business administration, if all of those types of or those majors relate to your degree or are acceptable to your position, then you would have to show how that the coursework related to those positions relate to your duties. So the more types of backgrounds that you accept, or degree backgrounds you accept, the harder it will be able to prove specialty occupation and less likely to be approved. So you may want to consider narrowing your degree requirements, or at least have them very closely related. So the focus will be really not so much on the field of study, but how it's related to the work that you're requiring of your H-1B employee. As I mentioned here, the burden is on the petitioner, which is the employer, to demonstrate how each degree relates to the job. So that is I'm fairly certain that is going to happen this year. So if you're applying for H-1B, you really want to look closely at your educational requirements before going forward with the petition. So now going on to the numerical limits, the H-1B cap. So as many of you probably know, there is a limit to the number of new H-1Bs that are approved each year, or allotted each year. There's not been much change in this for the past 10 years. It's been the same. The cap has not been raised, unfortunately. So despite the high demand for H-1B visas, the government has not, or Congress has not yet raised that limit. So the limit currently applies to new H-1B employees, those who have not had H-1B previously. The typical example, that would be someone on an F1 visa, has OPT, and so they are in a student status, maybe working under their OPT work authorization, but they have never had an H-1B. So that's a common category of employee to try to apply for a new H-1B. Then you also have a cap exempt to cap subject employment. So we'll talk a little bit more about what cap exempt means, but there are people who hold H-1B visas that were considered cap exempt. But if they now want to work in a capacity that it would not be considered cap exempt, then they would also have to be considered in the H-1B cap. And it's almost as if they're a new H-1B employee. And then we also have those who may have new six-year term H-1B. So what that means is, as I mentioned before, there's a six-year limit to H-1B status that an employee can have. And if they have left the U.S. and now are eligible for a new six-year term, then they will be considered in the H-1B cap, as well as if though they were a new H-1B employee. So what is the cap? The cap is that limit of H-1Bs. We currently have a regular cap, which is 65,000 H-1Bs available for those who have bachelor's degree or higher, And I say higher because if you have a higher degree, you can still be considered in the regular cap. But if you hold a master's degree from a U.S. master's degree or higher from a U.S. college or university, then you can also be considered for the master's cap, which is the 20,000 visas that are allocated. Currently, most of the time, most people who apply, or many people who apply, already have a master's cap. They are F1 students who came to the U.S. and have a master's degree or higher. So there's a huge number of applicants for that do qualify for the master's cap, and oftentimes will exceed the 20,000, and therefore they'll have to be considered in the regular cap as well. So just to give you some background, this number is really amazing. But last year, the H-1B cap process occurred in March for the October 1st to September 30th fiscal year. So fiscal year for the government starts in October. And so we're now, of course, in January. So coming up, for this year's cap. The actual fiscal year is 2025, because anyone who is selected for one of these H-1B visas, their starting time frame would start from October 1st, 2024. So that is the fiscal year. But so for last year's fiscal year, there were over 757, well, there were about 757,000 H-1B registrations. And what's interesting and interesting about this, of course, and what you will see from the new rules that are coming out about registration, it is a problem, not a problem for those who are trying to get H-1B visas, is that a majority of those 757,000 registrations were by multiple employers for the same H-1B employee. So this is a way that many applicants are trying to have a better chance of getting an H-1B slot by requesting multiple employers to apply for their H-1 or register for their H-1B. So as you can see, the majority of the registrations were with multiple employer H-1B registrants, whereas only 350,000 were single employer, meaning that the H-1B employee only had one employer register them. So out of that huge number, 110,000 or almost 111,000 registrants were selected. Now that is more than the 85,000 that are available, and they do that because oftentimes people don't apply, even though selected, or that they were not qualified for the H-1B and their petitions were not approved. So they kind of give that buffer to allow for those kinds of circumstances, so that they will ultimately give out all 85,000 visas that year. So procedurally, the timeline typically for H-1B cap, we haven't yet got the official time frame. This is an estimate, but it's based on previous H-1B registration timeline. So usually the electronic registration period for those who want to compete in the lottery is usually in the first half of March. And then by the end of March, the government makes its random selection of 85,000 or more registrations. By April 1st, usually electronically, the employers are notified of their selection, or if they are selected. And if selected, then there's a deadline to submit the H-1B petition, the actual petition to the government usually by the end of June. Now, typically, if you do apply for, or you are selected and you apply for the H-1B, the start date, the earliest starting date would be October 1st. And typically, most people will indicate a start date of October 1st. So that's the process. Now, there are some changes coming up. As I mentioned, again, this is a proposed change, and I do not believe it's going to affect this year's lottery. More than likely, it will affect next year's lottery, or next year's H-1B cap registration period. But the proposed rule is that instead of the selection being employer specific, where right now employers apply or submit their registration with the individual H-1B employees' information, instead it will be based on the beneficiary meaning the potential H-1B employee. So that means in the case where if an individual ends up having multiple registrations by different employers, as I mentioned happened last year, then if that individual is selected, then every employer who filed for that individual will be notified. And then the individual must then choose which employer is going to actually apply for the H-1B petition. So it will be the employee's choice to pick the actual employer, but there cannot be multiple employers applying on the next step if the employee is selected. So that there's a lot more details to that, but in the time we have, we can't go more specifically, but it will be quite a bit of a change what's happening today. And the thought is that this should reduce the impact, or at least the work on behalf of the work that the USCIS or the government has to do to try to figure out who is selected and who can go forward with the process. Excuse me. So if you are preparing for the H-1B registration period, the actual information that's needed is not a lot in terms of registration, but we always advise that you still need to treat the process as if though you will be selected. So you want to be sure that if selected, you would have all the required information to go on to the next step of actually applying. So one of the first things to do is to determine whether or not the position that you have is a specialty occupation that would qualify for H-1B. Determine whether or not the wage requirements would be something that you as an employer or you as an employee would find acceptable. Determine what job locations will be part of the process, that the employee will work, and definitely make sure you have a very detailed job description that would support the specialty occupation claim that you make. Then, of course, you need to make sure that the employer needs to have all of their official information, what their official name is, the tax ID number, who's the authorized representative, and mailing address. Now, this may seem fairly straightforward, but those companies that have various entities, you really want to make sure that the correct entity is the employer of record or the employer that's registering. You want to be sure that the correct official name, tax ID number of the entity that will actually issue the payroll or the paycheck for the employee. You want to make sure you have the right one there. You also want to verify that information against your tax records to be sure that that official name is exactly what is listed on your tax records or your EIN tax ID number. On the employee side, make sure you have the full official name, country of birth, country of citizenship, gender, of course, passport number. So, and then, of course, make sure you have all the other immigration documents related to the employee so that it's very clear what their legal status is or what your legal status is, so that for that, if you are in the U.S. in particular and you want to be sure that you can, if selected, be able to change status, or if you're not able to change status, be aware that you might be required to go to the U.S. Embassy in order to activate your H-1B. And then finally, the education information. So that's really key to this. You want to be sure you have all the diplomas, transcripts necessary to prove that the employee is qualified, has the required date of required degree, and especially for those who are still in their still F1 students, still completing their degree requirements. You want to be sure that that degree requirement will be completed by the date of filing the H-1B. So as I mentioned, there's usually in the first selection process, if selected, the deadline is usually June 30th to submit the H-1B petition. So the employee must be fully qualified by June 30th. They must have the qualified degree in order to go to that next step. So before going through the whole registration process, you want to be sure that that is going to be the case, that the educational background or the educational degree is eligible by the time, by June 30th, for example. Okay, so that kind of concludes the H-1B cap exemptions. I do want to let you know again that you can ask questions along the way. We will address those questions. Just include them in the Q&A feature. So be sure to go ahead and enter your questions as we go along, or if something comes up later, certainly do that. We also have shared the presentation within the chat feature, so you should be able to click on that, my shared file comment there, and be able to download the presentation to your computer. So the next agenda item is going to be understanding H-1B cap exemption. So I talked a little bit about cap exemptions, and this is beneficial to many who are able to find this kind of employment. So what is cap exemption? So cap exemption, as we talked about the cap. So an exemption is exempting from the CAP, meaning that you can an employer can apply without having to compete in that lottery system. Instead, they can apply year round if they meet the requirements. So to meet the requirements of H-1B CAP exemption, well, I'll talk a little more about next slide, but the significance of CAP exemption, as I mentioned, is that you can file H-1Bs year round. You bypass the CAP process, and so this can be a real benefit if you meet the criteria, where you don't need to worry about the start date and all those other issues that come with the CAP. But you must meet very specific criteria. So what are the criteria? There are different categories of H-1B CAP exemption. Easiest one is usually employment by a college or university. So if you are a college or university, a nonprofit college or university, not a for-profit college or universities, but if you are a nonprofit college or university registered with the Department of Education, then you can apply for H-1B visas year-round for any occupation that qualifies. If you are a nonprofit organization, but you're not a college or university, but maybe you provide training programs, you have an affiliation with a college or university where, for example, interns from the students from the college come to intern at your facility as part of their course or part of their curriculum, then you could also be eligible as a CAP exempt employer. If you are an employer that is a nonprofit research or has a governmental research organization, you could be also exempt. Now, the other interesting way that well, let's skip over to if you are an employer that is not a university, not nonprofit, you are a private employer, for-profit enterprise, but you will, in conjunction with the employment, have the employee working at a qualified CAP exempt organization. So for example, if that employee will be working at some of the time at a university or college, or they might be an example of a physician who is working at a university hospital, or working at a nonprofit hospital that has a teaching program, then you could still be qualified for CAP exemption as well. And then the other interesting CAP exemption workaround is if you are someone who is either part-time or full-time employed by a university or college, but you also want to work with another enterprise, another employer, you can even if that employer is not considered CAP exempt, you can still work with that employer by that employer filing a H-1B petition for you, and you showing that you will continue working at the university or college or the CAP exempt employment while you're also working at the non-CAP exempt or the CAP subject employment. Little technical, but it is a good option for some who can work in that situation. And then the last CAP exemption is very specific to not the employer, but specific to the employees. So if you're a J1 physician who received a government-sponsored J1 waiver, then you are CAP exempt CAP exempt for your employment. So any employer, regardless of whether they're nonprofit or for-profit, can hire a J1 physician who is completing their government-sponsored J1 waiver, or after they have completed their J1 waiver, they can move on to any other employment without needing to be subject to the CAP. So how do you prove CAP exemption? Well, this requires quite a bit of information. So it basically, if you are a higher education organization, it's a little easier to prove. You just need to prove that you're a public or nonprofit, authorized by the state to operate as a university or college. Or if you have a 2-year program, so it's, for example, you have an associate's degree program, so it doesn't have to be a full 4-year degree. University can be an associate degree community college as well. If you are nonprofit and you're affiliated with a higher education organization, you provide that clinical training, or you provide some kind of training to to a college or a university for the purposes of their students, then you need to show your that you are not cap exempt. You are a nonprofit with your 501c3 exemption. You need to show that you have an agreement with the college or university for that kind of training, and typically we usually would like to see a supporting letter from the higher education organization. The third-party employment, which is the one I mentioned, where you are not you are a for-profit organization, but your H-1B employee will work with either a university or a nonprofit teaching organization. Then you would need to show, of course, that you, as the for-profit organization, has an agreement with the with that nonprofit organization to have that person work, or that employee work at that organization. So for the example of a physician, if the physician is you as the employer have an agreement to provide physician services at that nonprofit hospital, you would need to provide that agreement. Ideally, a supporting letter from the hospital or the organization that's going to host the employment there. And then you also need to show that there's an educational nonprofit purpose to that employment. So that's the current requirements for cap exempt organizations. Now, the proposed changes actually are going to make the process a little easier than it is now to prove cap exemption. So this is actually, in our view, a positive change. So here, the proposed change to the H-1B cap exemption, probably going to be active this year, is that the government proposes that you no longer have to show that you are going to spend the employee is going to spend the majority of their time at a cap exempt institution. Instead, if they spend at least half, which is 50% of the time, working for or at a cap exempt organization, even if you the employer are not yourself cap exempt, then you can actually bypass the H-1B cap process. It also kind of alters the rule that the duties of the employee must be directly related to the university's mission. So, for example, you no longer need to show that your physician, I would use the physician example because it's the typical example that we see, is going to be part of the teaching program. In fact, you can show that they are going to, advance the clinical work, the kind of clinical mission of the hospital, and that could be enough. Also, interestingly, it does not require that the employee be physically present if they can perform duties remotely for these cap exempt organizations. Then that is an option as well. So those are some of the positive changes for the cap exempt. Now, another area, and we're moving on from cap exempt to self-employed H-1Bs. So there is, in our view, there is the opportunity for self-employment. Some people feel that it's not possible to be self-employed or having ownership of your company that is sponsoring your H-1B. But we've done these for many years. It has been a loose policy that this can be done if you structured the company in a specific way. But if you have 100%, currently the rule is if you have, or the policy is that if you have 100%, even if you have 100% ownership, if the company is structured in a way where either a board of directors or some other person in your organization has the ability to hire, fire, or otherwise control your employment, as well as other employees' employment, then you can potentially have your own organization sponsor you for an H-1B. But you also have to, of course, it's not, I'm the president of the company and I can work in any type of company for H-1B. You have to show that the primary work that you'll be doing will be in a specialty occupation. So if you're a physician, dentist, engineer, IT professional who wants to start up your own company through the H-1B process, then you would need to show that you will be spending at least a good part of your time in the actual specialty occupation, not just management, but you will also be performing, the clinical work or the development work, those types of things. Okay, so another change that's coming up, which actually, again, is potentially a positive change. It has its plus and minuses, but the government is now going to more formally issue a rule, or is planning to issue a more formal rule that says that if an H-1B employee owns more than half of their company, you can still apply. So now they've kind of made it more official that even 100% owners can apply for the H-1B without having to make that specific corporate structure that I mentioned. You don't need to have the specific requirement of some other individual involved in your business who can now determine whether or not you determine your employment within the business. But you do need to show that you'll spend most of your time, over 50%, as I mentioned, doing that specialized work that's related to your education and your experience. But that also is positive in the sense that it's not 100%. So if you have some business management duties that come with your managing your company, then that you can do that as well. So it doesn't have to be 100% of the time that you're spending doing clinical work or doing development work or engineering work. But however, the trade-off to that, it looks like, is that if you apply through this process, instead of getting the 3-year visa that most people get for H-1B, you will only get 18 months for the first time you apply. The first renewal of that 18 months is another 18 months. So you will still get 3 years, but you're going to have to apply twice to get that 3 years. And then after that, you can extend another 3 years for the H-1B visa, as long as you meet the requirements. So I'm going to go very quickly through the end because I want to be able to answer your questions. So I apologize if it's a little fast, but these are other significant proposals that some of you may be of significance to you or to the employers. So one is that there's flexible on H-1B start date. So as I mentioned before, if you get an H-1B cap visa, then typically your earliest start date, or the start date that you had to put onto the application, would be October 1st. But now the government may change that rule to allow that you can have a later start date. It can be November 1st. It can be it can be any time in that fiscal year. It does not have to start from October 1st. Another benefit or another change would be the F1. For F1 OPT students, you get this cap gap extension. Right now, if you are in OPT and you are still have not used up your OPT, you still have time, and you file for an H-1B visa, and you receive and you get the registration, and you also get the H-1 or file the H-1B, then you would, even if your OPT expires before October 1st, you would still be allowed to continue working, but you would have to stop working on October 1st if you had not received your H-1B approval yet. However, now they're saying that now they're planning that if you still haven't gotten your, what they're planning is that they're now going to give you the option, the ability to have an extended time of the cap gap. So if you're an F1, as an example, if you're an F1 OPT student and you apply for the H-1B or your employer applies for the H-1B in June 2024, now your OPT will now extend all the way through April 1st, 2025, as opposed to cutting off on October 1st. And this is sort of because sometimes there's a delay. Well, there can be delays in processing. So this gives the opportunity to continue working longer while waiting for your H-1B approval. Another significant proposed H-1B change is the job requirements. Now, this is intended to avoid people applying for H-1B or employers applying for H-1B where they do not have any work available, but they're anticipating work in the future. So this is going to be a little more difficult for for employers who may be startups in themselves and still haven't gotten contracts, or their cycle of getting contracts for work is different. So you have to, as an employer, you're going to have to prove that you have actual work for the H-1B. So it's not enough to say I'm going to contract with the H-1B employee. They're going to be my employee, even if I have work or not. You're going to have to show that you have actual business that will allow the H-1B worker to actually work. So that job must be ready for the H-1B worker when they're supposed to start. And another significant one is matching paperwork. So you're going to need to show that all of the documents that you're submitting with your H-1B petition is very much consistent and match up to that job description. So for example, the labor condition application, which basically is approved by the Department of Labor, has to be clearly matched up to the job description, which means that if you're saying this person is a software engineer, you have to be sure that that software engineer job description really does match up to the labor condition application. So this kind of gives even though the Department of Labor has already approved it, this gives the Department of Homeland Security a chance to kind of question whether or not you actually have the correct labor condition application for the job that you're offering. So this is where you'll have to be very, very careful about the job description. And then another area that more so often comes up with certain occupations, like IT occupations. So in this case, if you are going to have an employee working at a site that is not controlled by you as an employer, you're going to be having them work at a client site or some other site. Well, let's say a client site. If they're going to be working at a client site, then the specialty occupation requirement is not going to be based on what you as the employer says is the requirement. It's going to be based on the client's requirements. So you're going to have to provide more from your client to explain what their needs are and to show that this job actually is a specialty occupation and that the employee has the actual background to perform that work. And then finally, there's going to be tightening up of workplace checks. This has always been, well, not always, but this has been around for about 20, 30 years, where the USCIS can, after an H-1B is approved, or even sometimes before, the USCIS can visit the employer's site or the workplace to determine whether or not there's compliance there. So this is a sort of an audit that can be conducted. And so the government is now having more clear rules, or not necessarily more clear, but more defined rules as to the fact that this could be a very standard part of the process. So employers need to be sure that they have all their compliance in place, be able to provide the necessary documents that are requested by the inspectors. All those things are very, very important after an H-1B is approved. So I will now go on to questions. I know it's covered quite a bit, but I want to, again, address those questions. Again, make sure that you have placed your questions in the Q&A section. And to be fair, we do have a lot of people on the call, so we may not be able to answer all of your questions if you've asked multiple questions, because we want to be sure that we allow each person to get one of their questions answered. So I'll go on and read the question. So the first question we have is, how do I find the job that will sponsor H-1B visas? So that is really kind of difficult to answer. It is more of, I'm not aware of any credible places that say, or websites or organizations that say, we're looking for H-1B workers, or we're willing to sponsor. Sometimes you will see that on a specific job ad, but it's pretty rare. Most of the time, my understanding of clients who come to us who have jobs, they have either started as a student OPT with those organizations, or they have just really done a job search and explained to their potential employer the need for an H-1B visa. Okay. Next question is, does the USCIS ever seek proof of income after granting H-1B to the individual? Yes, it has. If you have an audit, I just mentioned a minute ago about the audit process. So if the government comes to your work site and asks you to prove the employee asks you to prove that you're compliant with the H-1B petition. So part of the H-1B petition is an offered salary. If you're offering a salary and you're not paying a salary or not paying the minimum salary that's required, then that is a violation and that could cause revoking of the H-1B. So yes, it is possible. They don't normally send out a request in writing to everyone who is an H-1B employer or employee, but there is the chance of that happening as far or that requirement of proving income in an audit process. So it's important to keep records that the income has been paid to the employee. Another question, cap exempt scenario for nonprofit placing H-1B acting as third party to government agencies qualifies for cap exemption. If I understand that right, if you are a for-profit and you have your clients are government entities and you are placing them at those sites, potentially it could be cap exempt, but we would have to look at the specific entity because normally just government entity alone would not meet the requirements for a qualifying institution that's either nonprofit or teaching institution or a government research institution. So we would have to look at that individually, but we have had seen some that have qualified, but it's very specific to the organization itself or the client itself, what kind of entity it is. Next question is, can one apply for EB-1 simultaneously while their employer applies for H-1B? Yes. The EB-1 is a green card application. There is no connection really with an H-1B, which is a temporary work visa. So you can certainly apply for a temporary work visa and also apply for a green card. Let's see, next question. I'm just scrolling down. Okay, I have four more questions. Three of them are from repeat questioners. And so I'm going to, if you have a question before I end, if you could just place your question into the Q&A panel and not the chat. So if you did put it in the chat, please move it over or cut and paste it into the Q&A panel. So the next question I'm going to answer is, client would not want to wait those months and allow October 1st. I'm not quite sure. Client would not want to wait for those months and allow October 1st as start date. How can someone submit contract documents? Okay, I think if I understand it correctly, the client would be your client who is not wanting to wait for months to do October start date. I'm not sure how that would help, but the question was, how can someone submit contract documents? So that would be submitted with the H-1B petition itself. So if your employee is selected, then you would submit the contract documents with your client to show the work that's anticipated for that employee. Okay, so I have a few questions from those who asked earlier, so I'll go back to those questions. Can someone work on an academic H-1B right after F1 ends and then do a 3-year OPT with another company? So if you're asking if you can have both H-1B and F1 OPT at the same time, no, you can't do that. You can certainly apply for an academic H-1B cap exempt and receive a cap exempt H-1B after OPT. You do not have, after F1, you do not have to have an OPT before you can apply for, or your employer can apply for the H-1B. So you can go directly from F1 to H-1B. But if you're trying to, you cannot do OPT at the same time as working on a H-1B. But let's say if you are talking about the OPT after an H-1B, that's probably unlikely as well, because you will not be able to receive the OPT if you've already been out of school and on H-1B. So hopefully that answers it. I hope I understood that question correctly, and hopefully that answers it. Another question is, I have an employer who wants to sponsor me, but they don't know the process. How can they go about it? It's a church. What's the process? So that will take quite a bit more time. What I suggest is to actually schedule a consultation with us, including your employer, so that they can understand the process. It is pretty detailed and complicated, and it's not easy to answer in the few minutes that we have. So please feel free to reach out to us and schedule a consultation and include your employer with that so that they can understand that process. Another question is, can the employer apply for the PERM process if I wasn't selected for the H-1B cap, or do I have to get H-1B first? So no, you do not have to have an H-1B for an employer to sponsor you for permanent status through the PERM process. We often have had people who were not able to get the H-1B, but were able to go through the PERM process and get permanent residence. Now, the timing of that could be difficult because there is quite a bit of time that it takes for a PERM process for you to actually have work eligibility and actually get your green card. It can be right now currently 2 to 3 years. So if you're going to start that PERM process, it needs to be started as early as possible. And you may still need to, may still need to try to get an H-1B in order to continue working or consider another temporary visa if you're eligible for that. But basically, you do not have to have an H-1B in order to go through the PERM process. Okay, let me see. So I don't see any more questions. So before we end, I just want to again reiterate that the content here is for informational purposes. Everyone's situation is different. So I do urge anyone who has more questions and wants to know, get real advice regarding their situation, to schedule a consultation with one of our attorneys. I also want to ask a favor. If you enjoyed our webinar, please share your thoughts with a Google review. Your feedback will really help others discover this valuable information. And so I want to thank you in advance for your support of that. You will also receive the link in our follow-up email if you're inclined to provide us with a review. Feel free to contact us. My email address is here, but you can also visit our website and fill out our contact form. That will also get through to us as well. So I know we went fairly quickly. Hopefully this information was beneficial to you. And I thank you for viewing our webinar. Wishing you all a great day. Thank you.